Okay, we are going to begin. This is Pam Bridge from CLS. We're going to be talking about rights and resources for tenants at risk of losing housing amid COVID-19. This is part of our, every Friday we've been doing landlord-tenant issues. And today our speakers are going to focus a lot on the motions to compel. Next slide. Just about community legal services. Next slide. We are located in 5 counties: Maricopa, Mojave, La Paz, Yuma, and Yavapai. However, we're going to be going over information today that is statewide, and we'll let you know when we are just focusing on Maricopa. You can always email us for legal information. However, if you want to apply for services and you want legal advice, meaning you want us to, based on the law, give you advice about the consequences of something that's happening to you, then you need to apply for services. And you can do that by calling 602-258-3434, 8 to 3, Monday through Friday. I also want to let you know that next Wednesday, our lunchtime webinar will be on unemployment. We have been having so many questions about unemployment that we want to focus again on unemployment on Wednesday, and that will be Nina Targovnik speaking. And then on Friday, we'll be doing more landlord-tenant issues. You can always apply, you can always sign up for our webinars like you did this one by going to our website and signing up. Again, they're always free. So I am now going to turn it over to our speakers. At the end of this presentation, they will be able to answer any legal information questions. You can ask those questions by typing in the Q&A. And so I am going to go and hand it over to Janice Villapando and Stan Silas. They are both lead attorneys in our CLS housing unit. They're in trial every week, defending and representing tenants and evictions. So this is what they do every day. And so you're going to be listening to 2 of our experts. So I'm going to go and hand it over to our speakers.
Thank you, Pam. Next slide. Okay, as Pam said, we're going to be talking today about the matter of motions to compel the enforcement of the writ of restitution by the landlords or property managers. As you're aware, under the Governor's Executive Order 2020-14, that order was designed to stop constables or sheriffs from locking you out. Tenant, however, must continue to pay the rent. Landlord can still get a judgment against the tenant for certain evictions, and the judgment can still remain on your record and impact your ability to find housing. Next slide, please. What you have to do as a tenant to stop from being locked out. These are the steps that come before the constable seeks to lock out the tenant, and you're trying to make the constable aware that there is a delay that you're entitled to because of a COVID-19 circumstance. So you've seen this slide before if you've attended our landlord-tenant presentations. And later on, Mrs. Villapano is going to talk in a great deal about the steps to take when that motion to compel has been filed by the landlord. So again, you have to demonstrate you've been diagnosed with the COVID-19 virus, you've been quarantined, you've been ordered to self-quarantine by a medical professional because of your symptoms as defined by the Center for CDC, or someone in your household has been diagnosed with COVID-19 and you must be quarantined, or you have a health condition as defined by the center that makes you more at risk for the COVID-19 than the average person, or you've suffered a substantial loss of income as a result of COVID-19, such as job loss, reduced pay or compensation. Your workplace is closed, an obligation to miss, or you have an obligation to miss work to care for a homebound school-aged child or some other circumstance. Those are the financial circumstances related to COVID-19 that you can provide to your landlord to demonstrate for an eviction for non-payment of rent. You should not lose your housing. You should not be evicted. And when you give or mail the tenant COVID-19 notice to your landlord or property manager, you need to attach any supporting documentation available for one or more of the above listed situations. So the bottom line is, for you as a tenant, you have to provide this notice, which is the postponement of the lockout because of the governor's executive order requiring temporary delay of the eviction enforcement. So it's critical that you complete the notice, you check the appropriate box, you provide the available supporting documentation to your landlord, hoping that he or she will not go forward in eviction. But if he or she does, then you need to use this information to provide to the constable to assist him in making the determination that he should delay the enforcement of the eviction action that's been brought by the landlord against you. Next slide, please. Some additional tips. Because we're in this pandemic, things in the justice courts and the judicial system across the state are being handled differently. You're going to be addressing an eviction matter via the telephone. You're not going to be in justice court in person. So you have to make sure you find out when your case is going to be called. You have to make sure you know what the telephone number is, as Janice likes to call it, that special magic password, and you have to be on that phone call. And you'll have to sit there and listen to other people's cases being heard, and then your case will be called on that phone call. These are brief phone calls, and you have to be there, because otherwise, if you're not on the call when your case is called, meaning your case, the number, your name, the landlord's name, it will result in a default. And you'll have to try to figure out a way to deal with that after the fact. If you gave the tenant, if you gave that notice to your landlord or property manager, and the landlord or property manager still seeks to have you removed, they will seek to have the writ issued. They will give the writ to the constable. He will come out to your unit. You need to give the constable a copy of that COVID-19 notice with available supporting documentation to demonstrate that the constable should delay the enforcement of the writ. If the constable still intends to lock you out, you need to call an attorney immediately, or an organization like Community Legal Services for some legal assistance. The constable may believe that you have not provided enough available supporting documentation. And we believe, as we'll talk about it later, that you have to provide available supporting documentation that's available to you. And you may not have a duty to provide detailed amounts of documentation. But you definitely have to fill out that form. You definitely have to provide the information that you have and demonstrate that you should be allowed to remain in your home. And this is what you have to prove or provide to the constable. Next slide, please. Now, the guidance we're talking about, again, is for evictions during this COVID-19 pandemic. It applies to tenants that received eviction judgment in Arizona's justice courts. Tenants, as I've said before, have to complete and submit the COVID-19 notice to the landlord, which was dated March 24th of this year. And the tenant must acknowledge the rental contract terms of their lease will remain in effect. Those are all the things you need to do to be able to put yourself in a good position to challenge the issuance of the writ of restitution and to show the constable that you have a qualifying COVID-19 circumstance, which should put you in a position where the constable should delay the enforcement of the writ. Next slide, please. This is a notice that we added only to make it clear again. If you are someone living in a Section 8, you have a Section 8 voucher, and that's the manner in which you, that's the financial mechanism for your housing, or you're living in housing that's subsidized one of the various housing programs listed here. Under the CARES Act, which is a federal statute, the landlord may not file an eviction for non-payment of rent or charge you late fees. That's a violation of the CARES Act, which was recently passed, that addresses those tenants who live in federally subsidized housing. Pay attention to that, because if that is the case for your housing, the landlord can't even file for an eviction against you for non-payment of rent or charge you late fees. And you want to bring that to the judge's attention immediately if you're subjected to an eviction. Next slide, please. Okay, this is the part of our presentation where we're going to talk about the motions to compel. I'm going to turn this part of our presentation over to Janice Filippano. Janice?
Thanks, Dan. Okay, so we defend a lot of these in justice court, and so basically I find it helpful to think about the governor's executive order as applying to these extraordinary times and intending to not increase the number of homeless people or the number of people that are subjected to the virus. So that's its general intent. And the law enforcement officials who enforce writs of restitution, and those are the lockout provisions following an eviction judgment. So the eviction judgment decides two things. The judge decides if it rules against the tenant that possession and damages are awarded to either one of those are awarded, or both are awarded to the landlord. And so when it comes to writs of restitution, the governor's order starts to act and apply after that judgment is entered and done. And so the tenant who is interested in defending and staying in the property who's affected by a COVID-19 condition needs to look forward and pass the eviction judgment. So it's the constable's job to perform or execute a lockout in accordance with a writ of restitution. And so the executive order really operates on the constable. In other words, it says, constable, when a tenant can document and prove that they have one of the qualifying conditions, and I don't know if we can bounce back, but we showed the COVID-19 qualifying conditions form with check boxes. And so the tenant asserts and informs the landlord that they have one of those qualifying conditions or more than one of them. And it's helpful to be able to provide support documentation. So the documentation can be, the notice and documentation can be in somewhat non-traditional forms, a text, an email, fax, other things besides formal court service of documents. So, and if you look at the third bullet point in this list, it is true that the constables have some discretion in when they come out following an eviction judgment on what they do with a writ of restitution. And it varies all over the planet. And guidelines are hard to find these days, and there's a lot of confusion out there. So the smart tenant can have their documentation lined up and the form that we showed earlier filled out. I think it's on the CLS website. And I think that the Superior Court or Justice Court provide that too. So documentation truly helps the constable to know what to do next, and it helps the landlord be notified of what their rights going forward are and their limitations as well. So can we go to the next slide? What follows if the landlord has determined that they still, for their own, that they still want to retake possession of the property despite the governor's executive order, they have to ask the court for that. And so they're going to file something called a motion to compel. And really that means maybe the more filled out name for that would be the motion to compel the constable to enforce a writ of restitution. That's a long way of saying the landlord is going to ask the court's permission to instruct the constable to go through with it and do the lockout. In order to get the court's permission, a landlord has to meet a certain burden of proof, which we'll talk about on the next slide. But let's stay here for a moment. There are some recommended practices, and you'll see in the second paragraph on this slide, it says expedited motion. These are kind of emergency times, and the landlord will be asking the court for a pretty extraordinary remedy to override the governor's order. And the tenant has to gather and meet their burden of proof. So it's been decided that it's in the interest of expeditious justice that these things should be decided rather quickly. So 5 business days is a time frame that's been stated out there. So these things run fast, as do underlying eviction actions. Okay, so can we go to the next slide? Okay, I'm reading ahead a little bit. In my experience in court, the second bullet point is what I've been talking about. The landlord makes the request of the court, and then the landlord's burden is to show that it's in the interest of justice, judge, or pursuant to part of the Landlord-Tenant Act that contains some of the more urgent and serious breaches of a lease. And those are things like criminal activity, drug-related activity. In other words, things that are urgent and would help the court understand that the landlord needs the possession of the property back, despite the governor's executive order and its intent to keep people in place. So if that makes sense, the landlord provides an argument to the court, supporting documentation if they want to, and they try to meet that burden and satisfy the judge that they're asking for the remedy, that it's a just thing to do. On the other side, and by the way, what they don't have to do, and probably it's not advisable or really efficient for the judge's purposes, to retry an eviction action. So in other words, this motion to compel hearing, if the court sets one, isn't about why the eviction is right or wrong. It's not an appeal of the eviction. So the landlord would want to refrain from rehashing that evidence, because the court needs something else for a motion to compel, and they need to be responsive to that. The tenant, too, has to be responsive, and the tenant has to show to the court, I meet or have in my household a qualifying condition, I call it condition, or qualifying circumstance. Again, those are the check boxes on the form. It can be something like, I must now care for a child who is not with school age but not in school right now. Or I had a client myself who was waiting for an organ transplant and was on immune system suppressing drugs, and that made them more susceptible and more at risk for the virus, and not a good person to be out and about or rendered homeless. So the circumstances are different. Some are financial and job loss related. It has to be related to the pandemic. Well, Judge, I was laid off from the Amazon warehouse, and things like that. Out of respect to the court, the tenant should submit to the court documentation of it to help the court make the decision. It's helpful. I suppose it's not absolutely mandatory, but evidence is a strong factor in the tenant's favor, so you want to provide that. Yesterday, I had submitted evidence on behalf of the tenant. I was defending a motion to compel. And what was helpful to the court, this person was an Uber driver. So he provided statements about tips and wages from before the pandemic, and then once it hit, and they obviously, Uber business tapered off significantly. And so by providing that to the court, it supported the court in making a decision that, yes, this tenant meets the qualifying condition and is entitled to the protections of the governor's order. Okay, next slide. Okay. Before we have a little bit more time, I wanted to make a note. The courts are scrambling to be able to give everyone due process and hear the litigants' sides of the story and review their evidence. So many of the courts, most of them, have set up virtual courtrooms. And what that means is a tenant who, I'm talking to tenants now, I'm talking to landlords as well. If you want to appear in court on a motion to compel or to defend an eviction or pursue an eviction, you must call into the court, and there is a passcode to be punched in. It's not hard. I'm amazed at what I've seen so far in terms of the justices of the pieces, their ability to juggle 34 phone calls at one time, and it runs rather smoothly. I'll also mention that those phone numbers are something it's best to call into the court, if you can, to the clerk's office and say, you know, I am scheduled for a hearing on X date. What number do I call? What passcode do I put in? That's if it's not on the documents you've received for court from either the opposing party or the court itself when it sets a hearing. So you want to pursue that. I don't think many courts are able to reach out and phone up a litigant and say, hey, you have a hearing right now. Do you have evidence for me? It's just too much, from what I've seen. Also, there are email addresses, and the clerks have done an awesome job of delivering documents to the bench so that the judges can review them, but you need to email them to the right place. Typically, they can also be faxed, and those connections are things that you would need probably to call the clerk's office to get the fax number and the email address. Some courts now are requiring material to be in as soon as possible, as soon as you possibly can get them in. And so it's worth mentioning, and exhibits, pleadings, anything else that you want sent to the court, try and do it the day before, 24 hours in advance would be ideal. And that's all I have.
Okay.
Thanks, Janice. We have a couple questions. Wait, Stan, do you have some other remarks?
No, I do not.
Okay. So the first question is, how can the tenant provide documentation over the phone?
You can't provide it over the phone. You would have to, as Janice said, get that documentation to the court by way of a fax or by way of email, or you drop it off in person at a drop box that I believe some of the courts have. So that is a challenge. And if you don't have access to a computer, then I would think the next best thing would be a fax, but you need to follow that up to make sure the court got your documentation. So this is a burden on tenants to ensure that the courts receive their paperwork, and you have to religiously follow up on that process.
Janice, you mentioned email address. What email address are you referring to? Janice?
Sorry,
Okay.
the clerks for each of the precincts justice courts have a separate email address. And I can't recite to you. They're pretty long, and the best way to get those is to call the office of the clerk of the court. We might want to look into if it's possible to post a list of the justice courts that are accepting emails and faxes, maybe those numbers. So
you think to call the clerk and ask, get the email address, and find out how they want you to submit documentation. Is that what you guys are saying?
yes, at this point.
Okay. So what happens if what happens to the tenant if they don't get a notice of the motion to compel and the constable comes and locks them out and they never knew about the hearing?
Well, this is Janice. In that case, a default judgment would have been issued enabling or compelling the constable to execute the writ of restitution. So the constable would be acting in accordance with a court order, and I suppose that would be provided to the tenant if they were on the scene. As for...
Let me jump in there, Janice.
Thank you.
You're welcome, because that is a situation we're dealing with. Not so much it was it was a default because our client either was on the phone and didn't know what to do or wasn't on the phone call. But the point was they got the judgment. He wasn't home. They got the judgment. They got the writ. He wasn't home when the constable showed up. But he had provided the documentation to the landlord right after the judgment, the COVID-19 notice form seeking a postponement. We had to go back, file a motion with the court seeking to have him reinstated back into his home, making the argument that the landlord had the information, should not have proceeded with the writ, but at the very least, the constable has now been made aware of the notice and should not have executed on the writ. So we're trying to get the court to go back and look at this situation. After the fact, unfortunately, the tenant was put out of his housing. So we're seeking to have him reinstated back into his home.
So are you saying that in that situation where the tenant didn't get notice of the motion, the constable comes, whether they lock him out, so should the tenant go back to court and file something at that point? Like, I mean, what should they do?
Well, in the situation I'm referring to, it wasn't the motion. It was the fact that the landlord was aware of the tenant's COVID-19 circumstance, sought the writ anyway, gave it to the constable anyway. Constable executed it, thinking perhaps that on the normal course of business. We had to make the constable aware this was not the normal course of business. Tenant had a COVID-19 circumstance. The landlord was aware, and the constable should not have executed on the writ. That's what we're trying to do now, is to put him back where he should have been.
So what I think I hear you saying in that situation is, first of all, they should probably call like CLS if they didn't get notice of the motion, right? And then two, they probably should contact the court and let them know they never got a notice of the motion, right?
Correct.
Okay. What happens if the tenant appears at the hearing, and the judge decides that they still haven't provided enough documentation to the landlord? What can the tenant do?
Janice, you got an answer for that from your experience?
That's difficult. I've had a tenant actually email while the judge was on the bench talking to the litigant, more documentation. She was very accommodating of him, and I'm not sure that would always happen. So possibly the tenant could ask for more time in order to provide the court and promise to deliver it in a certain fashion within a certain number of hours, and see if the court would be willing to reconvene the hearing. I mean, that's something that I would try. Other than that, I've had a judge rule, decide that documentation didn't prove by a preponderance of the evidence that the tenant had a COVID-related medical condition and rule against them. The judge then instructed the tenant of what to expect next.
Can the tenant appeal that decision? Can they file an appeal and appeal that decision by the judge?
I haven't found anything in administrative order to suggest that. I don't know, but I'm just going to say something in conjunction with Janice said. We can come back to that. According to the guidance, it states if the motion raises a factual issue regarding the notice of a qualifying condition, the motion will be granted unless at a hearing on the motion, the tenant provides the required notice and sufficient evidence of a condition that qualifies for a delay of enforcement of the writ under the executive order. So all of this is based on the tenant having to demonstrate that they provide the required notice and sufficient evidence of that condition that qualifies for a delay of the enforcement of the writ. It's very nebulous, and the discretion is given to the justice court judges to determine if the tenant has met that burden, so as to show that they should remain in their home. I don't know procedurally if there is a right under the guidance to file a notice of appeal against the judge for issuing the writ. I think the way to handle that would be to look at the rules of procedure for eviction action, understand the way writs are issued, and challenge the writ, which is what, and try to have that writ squashed, which is what we're doing in our situation. So yeah, it's not an appeal, it's a motion asking the court to quash the writ of restitution that's been issued, and you lay out the facts and the law under Rule 14C of the rules of procedure for eviction action. But in the meantime, the client's probably going to be outside of the home trying to gain access to get back into the home under this scenario.
Let's see if they have any other questions. I want to point out too, we forgot to do this in the very beginning, but we'll do it now, that beginning June 1st, courts are going to be reopening, some courts sooner rather than later. And in Maricopa County, the Superior Court judge has stated that all litigants must wear a mask if they're going to be in court. So just trying to make sure we get the word out to everyone that if they're going to if they're going to court, if they're going to be there physically, they need to bring a mask. It's really, really important. And so if you can help us spread that word, that would be great.
And I would say, getting back to what we're talking about here, Janice's point about staying in touch with the court, giving them correct phone numbers, email addresses. I think if you have given that COVID-19 notice seeking postponement, you as a tenant or an advocacy group, you need to be proactive. You need to recognize and have a conversation with the landlord or the attorney, or the landlord, to find out if he or she is going to accept it and allow you to stay there. If they're going to challenge it, then you need to check your mail or your email address religiously to see what's coming down the pipe. Because if you don't let them, if there's no way for the court to let you know that you've been served with, that one, there's a notice that the motion has been served by your landlord's attorney, and a court date has been set, you don't have that information, you're going to be defaulted. The constable's going to show up and they're going to lock you out. So you really have to stay on top of this when you think that the landlord is not going to just accept that form and let you live your days out peacefully. You're going to have to be proactive.
And Stan, I really like what you said too, because that's always been a theme on our things, is the communication should start with the landlord, right? Trying to talk with your landlord. That's the first step. If you're in court, that means that things didn't work out, but you can keep talking with your landlord. But usually, a lot of things can be resolved just through communication and then documenting anything that you've agreed to, right?
Right.
Okay, that is all the questions we have now. Again, I want to encourage you, these motions to compel are a little complex. We're looking for more guidance from the courts on them. Again, as they stated, we CLS does not believe that the standard should be that the tenant has to bring everything that they have. They have to bring what they have, but they don't need to go out and look for stuff, but you need to prepare yourself for those hearings. So we really suggest reaching out to CLS if you get that motion to compel.
And one other thing, Pam, for the clients out there, if they receive an eviction notice for material irreparable breach under 33-1360A, the more serious stuff, as Janet said, you need to prepare for a different kind of battle, because there is a theory out there by some landlords' attorneys that they don't even have to go back to court, file a motion, and seek to have a judge issue an order. There is a belief that perhaps under that particular type of eviction, that they can conduct themselves in a manner which is business as usual. They can get the judgment, they can seek the writ, the constable can lock you out, and there is nothing you can do about that under this the governor's executive order. We think that's wrong. We think that you still, the landlord attorneys and the landlords still need under the executive order and the guidance to go back to court, file a motion, obtain an order, and have the judge determine that you should be removed because it's in the interest of justice or it's pursuant to litigation brought under ARS 33-1368A. So when you see those types of eviction notices, be doubly prepared that landlords may decide they're going to move on you without trying to go back to court to to file a motion, and the constables may go along with that. So it's something to pay more attention to and be prepared to fight it if necessary.
Also, we're getting close to June 1st, Monday, right? So tenants are going to need to pay rent. Stan and Janice, do you have any words of advice about rent?
Janice?
I do. I neglected to say earlier, one of the things to assure that this relates back to the motion to compel. And so if a tenant wants to avoid having the constable lock them out, one thing it's important to assure the courts, the governor's executive order said that, and the best practices memorandum that instructs the courts or guides them on how to proceed. The tenant would do well to assure the court of two things in addition to documenting a qualifying condition. One, I know that I am not excused from paying rent, that rent keeps accruing. And two, I know that the other provisions in my lease agreement, my rental agreement, are still in effect, even though even for the duration of the governor's order. I just wanted to add that.
Great. Stan, anything else?
Pay the rent on time, as I said before. If the landlord refuses to accept the rent, put the rent money in the bank. Document that effort. And here's another tip. Stop using these Dropbox things if you can, because the Dropbox situations have led to more tenants getting caught up in an eviction, and they can't prove in these 5-minute mini trials that they actually put the money in the Dropbox, and now the burden is on the landlord to demonstrate that they didn't get it. They shift that burden back to the tenant, and the tenant can't meet that burden. I've had a number of clients, so is Janice, in these Dropbox situations. Be very careful about them. If you have to use them, bring someone with you, take a picture, you put that money in there, keep a copy of that money order or check, because people tend to misuse those Dropboxes on behalf of our clients, and then our clients cannot demonstrate that they actually put the money in the Dropbox. And on top of that, you charge all those late fees from the time when the landlord claims they didn't get your money, and you charge the attorney's fees from that when they file that eviction action. And so you don't have all those additional funds in conjunction with the monies in your fund. Perhaps the check never got cashed, so the money's still in your account, but you don't have the late fees and you don't have the money for the court costs, so you're going to get evicted. So I cannot stress, be very careful about these drop boxes and leaving your money there and thinking everything is okay, because it may not be okay. So be very diligent about that.
All right, that's great advice, Stan. That's all the questions that we have. Again, I want to remind anyone watching, they can always email us any legal information questions. We think the law is, hopefully we'll be getting more guidance about it in the future. And you can always apply for services at CLS. I want to thank Janice and Stan for all of their time and thought into this PowerPoint. We're grateful to have all of their experience along with this information. And so thank you and have a good weekend.
Thank you.